called out of turn, and the appellant has submitted a video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se
All right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that. That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes, okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off. If you want to have oral argument time, you may stand up and give it to me. You have 5 minutes. Your time has started.
Right. May it please the court. My opponent's entire argument relies on a fiction that I somehow agreed to an arbitration clause that was buried deep in a contract. The facts and the law both reveal why this is not true.
Can you please raise the right to you? Okay, go ahead.
May it please the court. I come here today a humble pro se. My opponent is a principal in one of America's largest attorney firms, and his client is a very large insurance company. The question before you is like unraveling a shell game. Which cup is the bean under? Is it contract A, contract B, or contract C? We start with B and under contract B. We all agree the bean was there in the beginning. It has no arbitration clause. Next, an automated system called FieldNet shuffles the cups. My opponent would like you believe that the controlling contract bean ends up under contract A, where there's an arbitration clause. But did it really get there? That's the question before this court. 3 critical facts distinguish this case. First, I began working for MassMutual under a fully executed B contract that contained no arbitration clause. This was a complete binding agreement that MassMutual now attempts to dismiss as merely a receipt of policies, a clear mischaracterization designed to facilitate their bait and switch. Second, I explicitly refused to falsely represent that I had never been convicted of a felony, as required by paragraph 4 of the A contract. The record conclusively shows my truthful yes answers to the felony questions in FieldNet. Third, after my rejection, someone or something changed those answers without my knowledge, then checked I accept on my behalf and submitted the application. This fact is absolutely undisputed but my opponent continues to ignore it throughout his pleadings and will likely do so today. This issue alone begs remand for discovery. The lower court's misapplication of Flores rests on 4 fundamental errors. First, on the proposition that signatures are not required when there's objective evidence of intent to be bound. Here, the evidence shows the opposite. My explicit rejection of paragraph 4 and ongoing performance under the B contract demonstrates I did not intend to be bound by the A contract. Moreover, it's important to note that had my answers not been changed, management wouldn't have accepted it. So there's no way that the bean can be under cup A. Second, unlike Flores, which involves sophisticated commercial parties of equal power, this case involves complete novices with 0 industry experience. Mass Mutual's attempt to characterize our valid B contract as merely a receipt of policies reveals their strategy. Lure inexperienced recruits in the door on one set of terms and then unilaterally post arbitration later. Third, the constitutional implications of waiving trial rights through arbitration demand a higher scrutiny beyond the mere indemnification provision in Flores. Fourth, compelling arbitration in this case contravenes the public interest. When corporate tactics stay hidden in arbitration, they eventually lead to Mangionis and national headlines. The public has a legitimate interest in seeing how contracts are formed, altered, and enforced, particularly when heavily regulated financial institutions like Mass Mutual are involved. These institutions control trillions of dollars of public money and operate under special regulatory privileges. Private arbitration of these issues shields important legal questions like misclassifications of employees from proper judicial scrutiny.
You'll have time on rebuttal. Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the court. I'm going to just address a few points because I do believe our papers really do address many of the allegations.
Was it possible to accept just the B contract?
No, and in fact, on page R29, by respondent's own submission, it states, quote, unquote, and actually even emphasized in the submission that it was required for anyone to perform services for the agency to complete both the upfront contract and the A contract. That is from the motion papers that appellant submitted on his own. And so there's no dispute by either party that both the upfront contract and the A contract were both required in order to perform services for the entity.
If I understand the record correctly, your adversary sought assistance in completing this application process and sought the help of the very person who helped him complete the process, correct?
That is correct.
And the evidence with respect to how that application was being put into the computer showed that your adversary attempted to hit submit on several occasions in contravention to his assertion that he never attempted to have that part of the contract admitted.
That is also correct.
I'd like to move to another area, the registration agreement.
Yes.
Now, certainly, for that agreement, there was a box to say, I accept. It was checked. Yes?
Yes.
Okay. And so this registration agreement also had an arbitration clause.
That is also correct.
And so there's no doubt. Well, let me say it this way. There's no, let me find the right word. There's no dispute that plaintiff signed that registration agreement where he agreed to all of the terms, including the arbitration.
Correct. And for clarification, the registration-only agreement comes into play once there is an attempt to sell the FINRA securities, backed securities. So that's not one of the onboarding initial requirements
Oh, I
of the
know.
contract, but yet both the A contract and the registration-only contracts with requirements for arbitration do cover the entire scope of services that are being performed by any agent.
You can continue.
I actually, those were the main points that I really wanted to address, especially the fact that both parties do say that the A contract is required. With respect to the attack on the constitutionality and public policy grounds, unless the court has questions about that, I feel that we do not need to address those. I think there's longstanding principles in favor of arbitration. And I think really the facts on page Rs 120 to 123 really do show that there was a manifest intent for the parties to be bound by the contracts, whether or not there's a dispute of it being signed. So as you said, you have a very busy docket today. I'm fine resting on the papers for the rest of our submissions.
Thank you so much.
Thank you.
Counsel, you have a minute.
Whatever I am. May it please the court. The registration-only contract would be under Cup C. And that contract concerns SEC work. I never worked under that contract, so I don't see how that contract comes into play at all. Can you hear me?
Yes?
So a BB, although it is not a controlling case, I think gives this court some guidance with respect to contract alteration, as the lower court seems to be relying on the A contract to find consent to arbitrate. Here, in a BB, there was an allegation that the contract had the electronic process had flaws in it. Here, we clearly see that the electronic system had problems with it. I never claimed that I did not have felony convictions. I put those in the record. They came back in a signed contract with no answers. I don't know where those no answers came from.
All right, thank you. HSBC Bank versus